Tonight, we are already hosting our 9th lecture, and I'm very happy that Stefan Oeter from the University of Hamburg has accepted our invitation. Stefan Oeter is a professor of German and comparative public and public international law at the law faculty of the University of Hamburg. He's a former chairman of the Independent Committee of Experts of the European Charter for Regional and Minority Languages within the Council of Europe. He's also a member of the of the Scientific Advisory Board of the Federal Ministry of Transport in Germany, and he's a member of the Permanent Court of Arbitration in The Hague in the Netherlands. His main fields of interest in research are minority protection, humanitarian law, European and international economic law, as well as theory of international law and international relations. He's one of the co-authors of the Handbook of International Humanitarian Law, edited by Dieter Fleck, that some of you might be familiar with. Stefan, we agreed to change the format of this session and instead of a lecture, rather have a 30 to 40-minute conversation about how the European Convention on Human Rights can protect the environment during war times. And I believe it is important to note before we start that there has not been any case, at least no case that I'm aware of, that deals with war-related environmental damage before the European Court of Justice or any other human rights courts. Since we have an interdisciplinary audience, can you explain why such a case does not exist? Do you have any ideas why this seems to be so rare?
Well, I think if you look in the history of I would say that the territorial realm where the European Convention of Human Rights traditionally applies, it's evident that fortunately this for a long time was no geographical space which was plagued by warfare. When it happened, I think when war came back to, or serious international armed conflict came back to Europe in the 1990s with the Yugoslavia wars, the kind of internal, but also after the separation, dismemberment of the Yugoslav Socialist Federalist Republic, when the wars broke out, they were not members of the European Convention, so there was no possibility to raise the issue. I think there have been some marginal issues of warfare which were brought to the European Court on Human Rights, which was partly sometimes the Cyprus issue, which was the British participation in the occupation of Iraq, where it was about kind of application. Is this, did UK have jurisdiction? The court affirmed that. But these are, I would say, for the overall application of the convention, these are marginal issues. And well, one could say Russia against Ukraine since 2014 should have been an issue, but that's again a timing issue. It takes so long until cases are really decided by the European Court on Human Rights that I think we are, perhaps we'll see some cases, but and currently Russia is not a member state anymore. But there might be some cases of the older, let's say, time phase, which are still in the pipeline at the court. But I'm not close enough to the court to say something on these details.
I remember talking to some officials in Ukraine about environmental protection based on human rights and whether it's something the government would like to see happen in human rights courts. And people usually seem to be quite surprised that we can use human rights to protect for the environment in war scenarios as well. So I believe our webinar tonight is actually a very important webinar to raise the awareness that human rights also protect for the environment and prospectively could also be used later on.
Yeah, that's why one remark.
Yes.
I think it's clear that Ukraine still is bound by the European Convention and that you can raise issues there. But unfortunately, I think the serious problems come up with the Russian war machinery and the way they they operate. And unfortunately, that today is not an issue under the European Convention anymore.
Yeah, so you mentioned Russia is not a party anymore to the European Convention on Human Rights. At the same time, Ukraine is. Nevertheless, for the period that Russia was still party, and that leads up to September of 2022, we might have some scenarios related to the second invasion in 2022 that could make it to Strasbourg, to the European Court of Human Rights. Do you agree?
Yeah, I agree. Yes. One could say there might have been also been cases concerning Donbass, Donetsk, Lugansk, but there again, Russia was playing this kind of hiding game, kind of hiding its responsibility behind the kind of facade of the independence of these two people's republics. So I think it's not that easy of bringing a case concerning the operations in Donetsk and Lugansk between 2014 and 2022 before the European Court on Human Rights.
But we've seen like first cases of the European Court of Justice after or regarding the invasion in 2014, where the court ruled that, I believe it was August 2014, there's clear evidence that Russia was actually acting, and the European Court has convicted Russia based on these scenarios. So chances, I would say, are not too bad.
Yeah.
We need the cases, and we have also questions of timing, of course, after all.
And I've always argued in other contexts, mostly in humanitarian law, that this was a mere charade, and then it was quite obvious that there was effective control of Russia over the armed kind of units operating in there, so that under international law, it's really something attributable to Russia. But it means some additional effort in bringing a case.
Absolutely. I'm posting a document from the European Court of Human Rights with pending cases against Russia. So this does not only regard cases with regard to Ukraine, but also older cases that are still in court that have not been ruled on. In case you're interested in what kind of scenarios and on what timeline are cases actually dealt with by the European Court against the Russian Federation right now. Stefan, you are an expert at the intersection of human rights and international humanitarian law. Why are we even talking about this? What is special about the situation? And why are human rights also relevant in armed conflicts and wars?
Yeah, I think this is well, it's not so recent, but let's say, in my lifespan, it's a more recent development because traditionally I dealt with the issue not very intensely, but to a certain degree at the beginning of my career in the 1980s, and there still was a very clear understanding in the majority that law of armed conflict is a special topic. It's lex specialis, and human rights don't apply in a situation of armed conflict. This has completely changed in the decades since then. The International Court of Justice played an important role in that, in particular with its nuclear weapons advisory opinion and its wall opinion on the Israeli on the Palestinian occupied territory occupied by Israel, and the International Court of Justice, I think, rightly made clear that this is a non-tenable position, that human rights apply parallel alongside to humanitarian law, laws of armed conflict. There might be some special cases where humanitarian law provisions are lex specialis because they regulate more in detail certain issues. I would say, in particular, methods and means of warfare. That's something where human rights are not that helpful. But on the other hand, it's quite clear at the same time that there are lacunae in the regulation of humanitarian law, where humanitarian law doesn't give us anything. and their human rights clearly come in as kind of filling the voids.
Do you have specific examples for these kind of
Yeah,
scenarios?
I think this is really a relevant issue for Ukraine, occupied territories, because we have a very, if you look in the traditional set of norms on occupied territories, on belligerent occupation, you have some basic set of rules in the Hague Regulations of 1907, and you have another set of norms in the Fourth Geneva Convention of 1949. But they are, I would say, rather rudimentary. They give some general principles, but they don't regulate in detail what an occupying power should do, and should, in particular, what it should not do. And so, in that sense, it's a rather kind of, it's a set of rules with a lot of lacunae, and I think there it's quite clear that human rights apply, and the European Court on Human Rights in some decisions on the Cyprus cases, but also in these kind of UK occupation in Iraq cases, clearly said belligerent occupation is a situation where the state has the occupying state has such an effective control over the territory that it's jurisdiction in the sense of the convention. So even in Iraq, UK as a member state had jurisdiction and was judged along the kind of yardstick of the European Convention on Human Rights, and the same could be said for Russia. It's with occupying Ukrainian territories, Russia has effective control over these territories and has jurisdiction, and is in its behavior, in its practices as a belligerent, as an occupying power, has to be judged according to the standards of the European Convention on Human Rights. And I think there's a lot of ambit for the application of human rights in these situations. Another issue is kind of detention, in particular of civilians. There are some basic rules in the Fourth Geneva Convention, but again, quite rudimentary. And this again is an issue where human rights come in, obviously.
And we have a lot of case law on these scenarios.
Mm-hmm.
I'm posting a link to another document by the European Court of Human Rights where you can see all the case law relating to armed conflicts and also the different human rights that have been used during armed conflicts. Stefan, when we talk about the environment, what kind of human rights are of relevance here based on your perspective?
Well, I think first it's right to life, and
and the right to life is of particular importance when we talk about armed conflicts.
No, because the right to life comes in general. Its scope of application becomes relevant when we have kind of serious risks, environmental risks that put in danger the life of people concerned by these risks, and then the management of these environmental risks. I think this clearly falls under the right to life, and we have a number of case law of cases decided by the European Court on Human Rights, where the court has used the right to life as a yardstick, and has also come in some of these cases to a judgment of violation of the right to life. And if you think, for example, the way Russia is handling the big nuclear power in Zaporizhia, I think this clearly is, at least at its core, an issue of the right to life.
Absolutely. So with regard to the right to life, we have several categories where we have the right to life categorized with particular situations, such as industrial dangerous activities. It's also about nuclear waste or toxic waste. Based on these categories, and since we have never had a situation like Zaporizhia before, we can draw some comparisons. I completely agree with you. And that is something that is not...
But we have also enormous environmental dangers in the Donbass, because we have all these kind of sunk or sinking coal mines. We have chemical facilities in there. So it's a region due to its industrial history, which is full of environmental risks, and mishandling these environmental risks in a war zone creates enormous dangers for not only for the environment but for the inhabitants of the region. So it's not only nuclear power facilities that come under the right to life. Mm-hmm.
Absolutely. And also you raise an important issue that the protection of the environment always also includes the protection of humans and the protection of our health. Many health risks are coming from the environment. And here, when we talk about contaminated soil, for instance, it's the environment that is putting humans in danger and that is putting our health in danger. So there we see a very close connection that also makes it easier to use the right to life to protect parts of the environment in these kind of scenarios. I think that's something that we
and the other substantial right clearly is Article 8, the protection of private life and family life, because if you deal in the wrong way with environmental hazards and environmental risks, this has serious repercussions on the ways people can lead their lives. So this is not always kind of a deadly danger, but it can be, and we have quite an abundant case law of the European Court on Human Rights on these issues under Article 8, that mismanagement of waste disposal, of water supply, and there's a huge range of, let's say, of environmental risks which play into the scope of application of Article 8. Mm-hmm.
Absolutely. We have not really differentiated yet between the different kinds of human rights and then how far they continue to apply during armed conflict. So the right to life continues without any questioning because it's a so-called non-derogable human right. But
although one notice of care, because the European Convention on Human Rights has a clause that kind of that in situations of armed conflict, the deaths going along with the exercise of military force, they are in a way excluded from the right of life, and there's an internal reference of the European Convention on Human Rights in practice to humanitarian law, saying states have to obey to the standards of humanitarian law, in particular the rules on methods of warfare, and these cases. There the convention itself makes clear that it's lex specialis, humanitarian law is lex specialis. But this becomes already difficult for handling environmental dangers because humanitarian law doesn't tell us anything on that.
Well,
I think their human rights come in again because they have a much denser network of standards than humanitarian law, which traditionally didn't care about these issues.
Well, we have additional Protocol 1 and Article 35, Paragraph 3 that addresses explicitly the environment, but the standard of protection there is not clear. And I would even argue that based on the travaux préparatoires or the documentation when states were drafting additional Protocol 1, states didn't really want this to apply to any kind of scenario. With the experience of the Vietnam War, they saw that the public needs to address these kind of questions, but at the same time, they didn't really want to limit their warfare. So they came up with a very high standard that so far everybody agrees has never been reached. So yes, there is a lacunae.
I think you can argue that perhaps, but I think this is still an open issue that these special provisions in the additional Protocol 1 might be ex specialis for issues strictly linked to methods of warfare. But as soon as we come, let's say, in issues of belligerent occupation and how the occupying power is handling these risks, I think additional Protocol 1 is not relevant anymore because it's not designed for that. It cannot be lex specialis because it's simply not designed for these cases.
No, absolutely. But when we talk about occupation and the protection of the environment in situations of occupation, what role does property play? I mean, we have parts of the environment that belong to public property, that belong to private property. Right now in Ukraine, I read the other day that the Russian Federation is attacking many public spaces.
Yeah, but in Ukrainian territory, in the non-occupied territories.
Yeah, that's, of course, yeah, that's in the to be occupied part, or yeah, in the fighting areas. Yeah.
Yeah. Well, I must say I'm a bit skeptical whether the right to property really helps us to handle issues of warfare. So issues of targeting and excessive collateral damages. I think there the right to property is not that helpful. We are back on that again in belligerent occupation. The laws of occupation in humanitarian law, they are protecting private and public property to a certain degree already in their set of rules. But I think there clearly is room also for additional parallel application of human rights. But I think in issues strictly linked to warfare, stricto sensu, I don't think that the right to property is helping us that much.
So we really have to look into the different scenarios, whether it's active conduct of hostilities or a situation of occupation. I was wondering, since we have like these different kinds of bodies, the law of occupation, the means and methods of warfare, active fighting, and we have a different range of human rights that we can apply here. Like, what would you recommend to people in Ukraine that are in a situation or in the occupied territories when it comes to their human rights? Like, what do they need to do to claim them? Because, I mean, can they claim with a Russian official?
Yeah, but I think that's opening up a box of problems, because as we said initially, Russia kind of has left the European Convention on Human Rights, and I think it left a bit before it was thrown out by the Council of Europe, one must say. So,
all on the same day.
But it clearly left. It clearly kind of terminated the applicability of the European Convention on Human Rights, because it knew that it would be thrown out by the Council of Europe due to its kind of blatant violation of all basic standards of not only of international law but also of Council of Europe law and the European Convention. But with that, you cannot kind of measure Russian occupying authorities to the standard of the European Convention. You cannot lodge complaints, at least nowadays. In the first month it was different, but in 2022, but now you cannot bring Russia to court for these issues. And Russia, as an occupying power, is the one who is really endangering the rights. So it's the responsible. This makes it quite difficult of dealing with that, and whether it makes sense of going against Ukraine, bringing complaints against Ukraine for something Russia does in the occupied territories. That's again a difficult issue. First, it probably doesn't make that much sense, and it's also legally problematic. The European Court on Human Rights had to deal with that in the Cyprus cases, where we had a bit the same situation, that Cyprus clearly could not be held responsible for what was happening from the Turkish authorities in northern Cyprus, because they had no control of what was happening.
I think one of the most recent developments right now is the creation of a registry of damage in Ukraine. It happened within the Council of Europe, and I'm posting a link here again in our chat. And they look into any kind of damage. I believe it regards the occupied territories as well as the territory still under Ukrainian control. I also believe, from what I understand, but there's not that much information out there right now, that they follow also a human rights approach, and it's also about the protection of property, for instance. For those of you that are interested in this registry and that if you have suffered any damage, I highly recommend looking into the link that I just sent to you. They have started their work. They have a legal section looking in any kind of claims that are collected there. It's pretty easy to report damage on the website. So check that out in case that's something that is of particular interest. And for us as legal scholars, it's also of interest what the registry is going to do once they have registered all the damage, because that's the next question. Once we know what has happened, what do we do with this? I think that's
yes. Well, at the moment, it's simply registering and getting a kind of survey of all these damages. At the moment, it's still difficult to do anything. I think one would need a moment like with the Claims Compensation Commission and after the Iraq occupation of Kuwait, where but there was a backing of the Security Council. There was a Chapter 7 resolution which enabled withholding certain oil revenues from Iraq, transferred in a compensation fund, and then this register could be used to compensate victims of the occupation of Saddam Hussein, Iraq, with that money. I think we are still, that's some issue of the future. We still have these discussions, let's say, of Russian central bank accounts being which are frozen, being later used for reparations and compensation issues, but it's quite clear that this will not happen soon.
Yeah. And like part of our GROMADA project is to look into citizen science and to look into data collection when the conflict is still ongoing, which raises particular problems, which is even more difficult than in peacetime. But the work of the registry might be something where we have some overlap, and it prepares the aftermath. So that's really the interesting part, again, from the legal scholar perspective here. Stefan, we have not talked about a right to the environment, a right to the healthy environment. Why don't we have such a right in the European Convention on Human Rights?
Well, when I say the European Convention on Human Rights is a quite old instrument. I think it's the eldest international human rights treaty which we have at all, because it was concluded in 1950, kind of taking up the impulse from the Universal Declaration on Human Rights, and so that's really a different layer of time, which is expressed in the set of rules of the European Convention. Well, we have a system of additional protocols where from time to time additional rights have been annexed, but I think the willingness of states to go into obligations concerning environment under the European Convention on Human Rights system was quite limited. So there was not that much political willingness of going that way. And the European Court on Human Rights, well, it has used the existing rights, let's say, for specific aspects, looking how can we interpret the existing traditional rights in a way that we can also tackle certain environmental issues where it's really has a plausible link under to traditional human rights. But the European Court on Human Rights, I think, is barred in methodological and legal terms of claiming an overall right to a healthy or decent environment. I think that's not possible under the convention.
Do you think times are changing, and at some point we might also, within the European Convention on Human Rights, have a right to a healthy environment?
Well, I think there's another problem with that, because the European Convention on Human Rights is more or less limited to the traditional civil and political rights. And abstains from regulating economic, social, and cultural rights.
But I mean, we have the right to property.
Yeah, in the additional, but the right to property, you could argue that's in a way that's still a traditional civil right and not an economic and social right. Also in our constitution, which is also clearly abstaining from every social rights, we still have a regulation of the right to property, and I think it's not an absolute boundary line, because we have a right to education in one of the additional protocols. So the states, in certain aspects, were willing to cross that boundary line, but in principle, I would say they are reluctant of going too much in the realm of economic and social rights.
For those of you who are interested in the human right to a healthy environment, we have had a lecture before by Amanda Krohn from Lund University, and I'm posting the recording in the chat, so you can listen to what she had to say about the right to a healthy environment in particular.
Yeah, but I think in a way it's depending on political will. If there would be a kind of a bottom-up movement in a sufficient number of European states demanding for that, if that would have political momentum, which would kind of force governments to take that up, we might one day see it. But at the moment, at least in medium term, I don't see a realistic chance of getting that into an additional protocol.
Yeah, I mean, there have been some initiatives within the Council of Europe, and there are manuals on human rights and the environment. There has been a discussion of a convention or another additional protocol, but I completely agree, the political will is lacking. And even though the environment and climate change are becoming more and more important to the people as well, states seem to be quite reluctant.
Yeah, I must say, traditionally, the environment is not one of the main points of the Council of Europe. When European states had started to struggle with issues of transboundary pollution, they used the forum of the Economic Commission for Europe under the United Nations framework, which at that time had the advantage that it was crossing the boundary lines of East-West, so because all Europe was in it, and not only the West. Council of Europe traditionally was the organization of the Western states. But this also means that for decades, the Council of Europe was kind of not acting in that realm.
We have a question from the audience. We are waiting for the English translation so we can address English as well. I'm sharing another fact sheet from the Council of Europe on how human rights protect for the environment without having a specific right to the environment. And here we have an English translation. So I'm reading it out. It seems to me that the European Union's okay, now we are talking about the EU. The European Union's approach to Russia is based on confidence in the readiness of the Russian government and people to comply with international law. However, in my opinion, this approach is completely wrong. Russia hides behind international law only when it is to its own advantage. In other cases, Russia completely ignores international law. So how can Russia be held accountable? The Human Rights Convention does not specify any consequences for non-compliance with its provisions. Stefan, what do you think?
Well, I think there is no confidence in Russia anymore. There was until February 2022 still too much confidence. I was over there, in particular, I would say also in German politics. I was an ardent critic of that, because I think after what Russia had done in 2014, there was no basis for any confidence in a law-abiding Russia anymore. But German politics and some politics also of some other states still behaved as if one could have this. But I think today it's clearly, and everybody in European capitals and in Brussels is aware that you cannot trust on anything, even if kind of pays lip service to international law. That's pure lip service. And the way Russia is leading war, it's systematically ignoring all the standards of laws of armed conflict. So how could you have confidence in Russia as a law-abiding state? Which opens up the question how to make it, how to activate responsibility. That's a difficult issue. I think the main point is Russia must lose the war. It's the only pay. Not in the sense I think we will not, or we, I would say, Ukraine and at the first hand, but also the Western states in the back seat, we will not be able to bring it to unconditional surrender as the Allied powers did it with the Nazis in 1945, and one probably even will not manage to kind of force it to capitulation and with an asymmetrical peace treaty like in 1919. This probably is not going to work, but still, if Russia kind of spends a lot of its resources and at the end doesn't gain anything serious, it has lost the war. And I think this would be a situation where one might start talking anew on responsibility and on kind of how to put it again in a framework where it must abide to the law. Before that, I think doesn't make any sense of talking on that.
Even though I would say it's quite impressive to see how Ukraine is trying to use any kind of venue law to fight Russia as well. So it's not only the fighting on the ground, but also the fighting in international fora, in international courts. So that's also important.
I think Ukraine has learned a lot how to invest resources in what experts call lawfare.
Exactly.
And I don't mean that in a cynical way. I think it's an effort worth, and I think Ukraine is quite clever in doing it. But kind of issuing procedures against Russia before the International Court of Justice, well, I hope if I think in usual timeframes, the war is not still continuing. At the moment, the ICJ is handing down its judgment, because that would mean the war would go on for a very long time.
Yeah, that's like one of the other downsides when we look into the legal means to address war. It takes time. So it takes time to go to the European Court of Human Rights because you have to go through your national system in general. There are exceptions where you can go straight to the European Court of Human Rights, but also with regard to the International Court of Justice, the discussion of a special tribunal in this particular case, all of it will take time.
Yeah. So I think the interstate complaint case before the European Court on Human Rights, that might go a bit quicker. But still, does that change anything on the ground? I'm skeptical there. It gives Ukraine a kind of symbolic victory on the kind of playing field of international law. But well, we are back to what we discussed before. I don't think that this will really influence Russian practices.
So the law will not solve the conflict. It will possibly not end the conflict, but it might be a means to address the damages in the aftermath, to do something good. But if it's not up to the people and the states that change something, the law is not going to make a difference either. This is not a very hopeful ending, but I would suggest that we stop the recording now and we open up the questions to